Hello, I'm Cameron Cooper, editor of the Law Management Journal. The journal is proudly published by the Australian Law Management Group, a committee of the Legal Practice section of the Law Council of Australia. ALMG is releasing a series of podcasts. They're designed to help law firms navigate the introduction of new anti-money laundering and counter-terrorism financing obligations. The new laws will come into force in Australia on July 1, 2026. In the third podcast of our series, we speak to Brendan Thomas, CEO of AUSTRAC, the government watchdog that will be responsible for regulating the new rules. In this interview, Brendan tells Trish Carroll, an ALMG committee member and long-term consultant to law firms, how Aussie firms can prepare for the new regime and what AUSTRAC will expect from them. We begin the interview with a discussion about the input that the Law Council and lawyers have had into the legislation.
To kick off, I'd really like to understand how you went about eliciting an understanding from law firms about the things that were of concern to them. You know, there was a big consultative process, and I'm wondering what themes came through specifically from law firms.
Yeah, thanks, Trish, and thanks for the opportunity to talk to you today. We've done quite extensive consultation since the legislation passed, and in fact, the government had done quite extensive consultation on the elements of the bill before the legislation passed and had significant involvement with the Law Council of Australia and the various law societies around Australia in drafting that legislation. I know they made quite a number of amendments to that based on that feedback. We started that consultation in pretty much as soon as the legislation passed so that we could hit the ground running in November last year. And we issued our first round of consultation then, and we had enormous consultation with the Law Council, with a whole range of law societies on the elements that would end up becoming the rules of the AML scheme. And we had lots of individual discussions with individual representatives of legal bodies on specific issues in relation to the development of those rules. We had a second round of consultation on those rules, and again, huge involvement with lawyers in the design of those rules. And they were published in August. Subsequent to that, we've been developing the guidance material, which again has been very extensively consulted on. And we've had specific consultation groups involving lawyers. We've had general industry forums involving all of the new bodies that are coming in under our regulation next year to help us design that guidance material. And we're still involved in more discussions with lawyers around specific guidance for lawyers, as well as the starter programs that we're developing for small and medium-sized businesses. And not only are we talking to representatives of lawyers, but also legal firms themselves. In fact, myself, I've done a whole range of consultations with law firms and people managing law firms, and we're talking as much as we possibly can to everybody that's coming in under this regime so they can understand our position in the regime itself, but also so that we get a better understanding of what their concerns are.
One of the concerns that we've heard from lawyers is a reticence to obtain the level of information that's required from their clients. Do you have any suggestions on how they can overcome that reticence?
Yeah, there's a couple of things I think to point out in the first place. So if a lawyer's client is a low-risk client, and to be honest, we expect most of their clients to be low-risk clients, there's really minimal information that they need to collect from that client. So they need to satisfy themselves that that client is who they expect that client to be. And that can be done relatively simply through some identification documents. And if it is a low-risk client that doesn't elicit any other kind of suspicion from the lawyer, they might not need to collect any other information other than that. And so for a lot of law firms, I imagine they're already doing that. And they can check our guidance and the rules to see what changes they might need to make to their existing processes to satisfy those things. But I imagine many law firms are already doing that. It's where a firm develops a suspicion about a client that they might need to collect more information. So if they're not clear that that person is who they say they are, if they're dealing with a company or a corporate structure and they really can't determine who the beneficiary is of that structure, who the beneficial owner is of that structure, then they'll need to make some further inquiries to satisfy themselves that they're confident that they know who they're dealing with. And if they still can't establish that confidence, then they can report a matter of suspicion to us. So if they still have a suspicion that someone's trying to hide their identity, trying to obfuscate the beneficial owner of a company, that's when they put in a suspicious matter report to us. So we ask them to do what's reasonable. We realise lawyers aren't police officers. They don't have any legal authority to demand information from people. They can do what's reasonable to try and satisfy themselves that they know who that person is or who the owner or the beneficiary of a transaction is. And if they can't establish that, that's when you report a suspicion to us. For some engagements that might involve a transaction and they're not clear on the source of a person's funds, again, we'd ask that they try and establish some certainty about where those funds are coming from, but that's only where they're developing a suspicion about not being clear about where those funds might be coming from.
When a law firm reports a suspicion, what happens after that?
Yeah, what happens with the report? Great question. Just to put people at ease, we get hundreds of thousands of these a year now from the businesses that we regulate, hundreds of thousands of them. Every day we get more than 1,000 of these suspicious matter reports every day. What we do with those reports is they come into AUSTRAC. They have a whole bunch of legal protections around them, which is spelled out in the legislation. So a lot of people are concerned that if they give a suspicious matter report to us, the person they're reporting on will find out about that report. There's a whole range of legal protections that make sure that doesn't happen. And in the 20 years we've been doing this, we have no examples of that happening. And indeed, talking to colleagues around the world, I can't give you an example of that happening. That material can't be used itself in a prosecution, but what it can be used for and what we use it for is to turn it into intelligence that we work with police, national security agencies, anti-corruption bodies, to turn into actionable intelligence around either criminal activity, to build pictures of criminal networks. And often the value of a suspicious matter report isn't just the report itself, but it's the aggregate of a multiplicity of reports about the same person or the same company structure. And that helps us build a bigger picture around that. And we marry that with other financial information or other information that we have to try and build pictures of criminality that we then provide to law enforcement that they turn into investigations. So if the police, for example, eventually prosecute a person, they can't use that suspicious matter report as part of the grounds of that prosecution. They need to develop their own fresh evidence for that. So it won't appear in a court bundle. It won't go to the defendant in a court case. None of that will happen. So people don't need to be concerned about that. But they should know that that information is used by us every day. And in fact, we provide direct access to our information to more than 5,000 other people who work in law enforcement and national security in Australia. And that information last year got searched 10 million times by those bodies. So it gets used extensively. Every time you open a newspaper or turn on the television and hear about an organised crime prosecution, particularly where it involves any kind of financial transactions, you can almost guarantee our suspicious matter reports or other reports are being used in those.
Gosh, that's incredibly impressive. It's almost like providing a public service if you've got a suspicion that you do that. That's amazing. Am I right in thinking that if I have given you the suspicion report, I can still carry on in acting in the transaction?
Yes, you can. So again, if I can give you some examples with the businesses that we currently regulate, as I mentioned, we get from Australia's biggest banks, we get hundreds of thousands of suspicious matter reports, and most of those are transactions that continue. Because a person develops a suspicion, that's not the proof that a crime has happened. It is what it says it is. It's just a suspicion. So you might think someone's trying to hide their identity. You report that suspicion, but in fact, perhaps the person wasn't trying to hide their identity. They just were, untrusting of a bank, for example.
Yeah.
But there are literally, I could tell you, hundreds of thousands of matters that get reported to us as suspicion where the transaction still continues.
Okay, well, that's fantastic. Something else that's come up is the proportionality principle. Can you explain how that principle applies?
Yeah, so we expect people to take action in proportion to their level of risk and the size of the business that they're in. So obviously, when we're dealing with someone like the Commonwealth Bank, they have an incredibly extensive anti-money laundering program. Many thousands of people in that bank work on financial crime. They do many hundreds of thousands of reports to us, and every transaction they're dealing with goes through filters that deal with risks around financial crime. For sole practitioners, for small businesses, that level of risk and exposure is much smaller, and the level of intensity of that program would be much smaller. And the action we take is in regard to the proportion of the harm and the proportionality of the risk that a business might face. And so people should bear that in mind when they're thinking about interacting with us. Is we expect you to put your best efforts in place to comply with the law, but we expect those efforts to be proportional with the size of your business and the extent of the risk that you're exposed to.
Okay, that's also comforting. Thank you. I guess it sort of leads to the role technology plays when it comes to avoiding breaching the rules. Can you talk us through your view on that?
Technology does play an important part in helping these processes be more efficient in the first instance. So if you do need to search for politically exposed persons, or you might need to search the internet, for example, to check on whether a person has been reported as a participant in a criminal case, for example. But they also form a particularly important part in helping you keep your records. So there are some records that people need to keep as part of this regime, particularly how you've satisfied yourself in relation to a person's identity or their source of wealth. And so that record keeping is an important thing to do. I imagine most law firms already have record keeping systems, and so I'd encourage them to think about how they might adapt those to meet these needs rather than necessarily expending huge amounts of money on different ones. But maintaining those records is really important, and we'll be asking people to show us how they might have satisfied themselves that they're implementing their money laundering programs effectively. And so they'll need to keep records of those things. And doing that through sources of technology makes that much easier and just makes it much easier for them to retrieve.
Well, there certainly is a lot of noise out there, if I could put it that way, about the type of technology and identification verification that's required. So from a small to medium-sized perspective, there's also a concern about the cost of compliance. Yeah. Have you got any advice for them about how to most practically and cost-effectively ensure that they're compliant?
Yeah, there's a few things I think to emphasise in the first part. So we've really tried to consider the situation of small business in how we're designing all of this regime. And so there are some things businesses need to have. So each business will need to have a chief money laundering officer, for example. But the law and the rules allow that to be the owner of the business, the senior partner of the business for small businesses. So for a small and medium-sized business, we're not requiring people to hire anybody new to do that. For a bigger firm that's complex, yeah, they'll probably need to get some specialised advice, but small businesses don't. That's really important to know. You can try and build that into your existing management structure, and we've been really careful to try and structure that in that way. Where people are participating in property transactions and information is flowing through the course of that transaction, the law and the rules allow the information, where there's agreements in place, to flow with the client. And so that is, if someone establishes the identity of a client at one part of a property transaction and that party is satisfied and there's an agreement in place, subsequent parties won't have to redo that if they have an agreement in place. And so that should reduce the cost. We've also listened very strongly to industry and looked at the experience of colleagues overseas, and the experience of small business was something that jumped out to us in examining that. And so we've done something which is quite different to other countries around the world, in that we're developing specific AML programs for small business. And we're doing that particularly with lawyers in consultation with the Law Council and law societies, and with some practicing solicitors, so that we will develop for small practices what we call a starter kit, but effectively they're AML programs. So we'll have a risk assessment in it for them, so talk about the kinds of risks that we'd expect them to see. And then it will have a lot of detail in there about what they'll need to do to be able to comply with the program. So they shouldn't then have to go off and pay for anybody else to develop a program for them. If they choose to do that, that's a matter for them. But we're really trying to limit the costs small businesses have to pay by doing as much of that work for them as we possibly can. And throughout the course of the next year, people will see lots of seminars, webinars, other material coming from us that they'll be able to access to help inform themselves and their staff about the new regime. And once it does start in July next year, we'll continue to provide material to small businesses and to legal practices that will help inform them about how it's progressing and the things that they need to do. So we're trying to do as much as we can to do work for small businesses so that they don't have to incur additional costs themselves. Nevertheless, nobody wants to be regulated. We know that. Nobody wants any additional administration. We fully appreciate that. If people don't have information systems that are up to scratch, they might need to invest some money to get those up to scratch. If people want to get external advice on making sure they're compliant with the law, then obviously they're welcome to do that, and there are plenty of people where they can get that advice from. But we really are doing as much as we can to minimise costs for small business.
Well, that's incredibly reassuring. I mean, the starter kits, that sounds fantastic. So I guess if I've got my small law firm hat on, and I think it's also comforting that clearly you can wear multiple hats So I can be the chief money laundering officer.
You sure can, yeah.
And also the finance director or whatever. Okay, that's fantastic. So given that those things are emerging, what sort of time frame should I be focused on to really start maximising the value of all of these tools and resources that AUSTRAC's providing so that I'm on track to be compliant by the due date?
Yeah, so there's a couple of key dates you need to bear in mind. So the obligations start in July next year, and you're required to register with us between March and July next year. And again, we're doing a lot of internal work to change our IT systems, and we'll be launching a new portal for that. So we're trying to make it as simple and as intuitive as it possibly can be to register with us. That needs to happen by March. From January, these starter kits will go out to businesses so they'll be able to see clearly what they need to do. But between now and then, it would be useful for people to familiarise themselves with the guidance material that we have recently released. We're releasing information on money laundering and how crooks launder money through small businesses. And so it would be useful for people to start to familiarise themselves with those. And more of that kind of information will come out on our website over the course of the coming months. People should also start to think about, do I need a chief money laundering officer, or can I do that job myself? Have I got strong information collection systems, or might I need to make some investments in those? Think about, you'll have to train your staff in your money laundering program once you get the starter kit. So you might start to plan when you might do that through the course of next year. Those kinds of preparatory things, I think, will help businesses start to get ready. And if I was running a small business, I'd start to put together a plan of what I want to do between now and when that legislation starts in July, and just start to organise myself around that.
Yeah, absolutely. And I guess in that plan, really tap into when these tools and resources are available from AUSTRAC as well, because you might save yourself quite a lot of money and anxiety by starting too soon.
We're trying to take the stress out of it as much as we can.
Yeah.
I mean, and again, I appreciate new regulation and new legal responsibilities is stressful for anybody to think about, particularly small businesses that are working very hard just to keep their lights on. But we are trying to take that stress out as much as we can and be as clear and as simple as we possibly can about what we expect people to do, and doing, as I say, as much of that for them so that people can pick things up and work. There's a few assumptions that we make that are important for people to understand. We know that this is new for businesses. We know for a lot of law firms, they've never dealt with money laundering before. They've never dealt with this issue before. They don't really know what money laundering is or what to look for. So we're not expecting people to be perfect when these obligations start, and we're expecting that there'll be a learning curve most people will be on, and we'll be dealing with that in the same way. So you'll find us to be quite helpful and informative. I know there's a lot of chatter around people getting fined by AUSTRAC kind of as soon as this regime starts. We have no intention of doing that. And in fact, if people are worried about how we do enforce the law, there's a clear section on our website that has all of our enforcement actions on it. And again, I'd advise people, if you're interested in that, jump on our website and have a look at that, and you'll see that we don't just chase small businesses down for not dotting their I's and crossing their T's. You won't find any cases of that on there, because we just don't do that. We look for people that are really non-compliant with the law, that people that are involved in criminality, or people who are turning a blind eye to crime. We don't jump down the throat of small businesses because they haven't ticked the right box.
Yeah, fantastic. Well, I'm feeling very reassured as an ultimate small business person. So I guess just to wrap up, what you've just outlined is really all designed to help law firms, and particularly the smaller end. I mean, the legal profession is really made up primarily of very small and medium-sized businesses, and you're really focused on what's going to be most helpful and constructive for them. Is that a reasonable assumption, a reasonable statement?
It really is. And before you mentioned I've been in AUSTRAC for not quite 2 years, a little over 18 months now, but I was previously the CEO of the Legal Aid Commission in New South Wales. And in that job, we engaged more than 1,500 small law firms to do work for us. And so I spent many years dealing with small law practices in New South Wales very intimately. I'm very familiar with the challenges that they have and the pressures on their work, very, very familiar with those. And very dear to my heart, actually, small law firms. We owe them a lot for the work that they do to benefit the community, and they do an incredible amount of work representing underprivileged people throughout Australia. And we want to make sure that they can continue to do that and also help us deal with this money laundering problem that we do have in Australia. If I could just say, we are really dealing with a significant problem, and What we're asking law firms to do through this regime is to help us, as the financial sector currently does, deal with this problem. It costs us $68 billion a year. And the money laundering comes not just from victimless crimes, it comes from human trafficking, it comes from drug dealing. It's the profits of serious violence. And we really turn the information that businesses that are regulated by us into actionable intelligence to chase these bad people down and lock them up where we can.
Well, thank you so much, Brendan. That was incredibly informative and illuminating. Thank you.
Thanks for the opportunity to talk to you, Trish. We're in a great discussion. Thank you.